Good evening, everybody. Welcome and thank you for joining us. My name is Julian Perez. I'm the Vice President of Risk Management and Regulatory Compliance at Dentalcorp. I am excited and honored today to have with me Lara Z and Nigel Trevethan. Both are partners with the law firm Harper Gray LLP. Lara is a partner who practices in the area of professional regulation and health law. She is the assistant chair of the firm's professional regulation group. Lara has acted as counsel for physicians, dentists, psychologists, and many other regulated health professionals. Lara articled with Harper Gray and joined the firm upon her call to the bar in 1996. She was in-house counsel with the College of Physicians and Surgeons of British Columbia for 2 years, from 2009 to 2011, before rejoining Harper Gray in 2011. Lara has been recognized repeatedly as a leading lawyer in the area of administrative and public law and healthcare law by Best Lawyers in Canada. Nigel Trevethan is a partner as well with Harper Gray and the chair of the insurance law group. Nigel's practice includes legal services to multinational, national, and regional insurers and brokers. A significant amount of his practice focuses on work with self-insured professionals and organizations. Nigel's defense practice focuses on large, complex litigation matters ranging from class actions to complex bodily injury claims, often including mass casualty events to product liability cases. He's defended many high-profile cases, including professional athlete concussion cases and class actions for product liability and personal injury. Nigel's the editor of the contemporary Canadian insurance law casebook, published in 2015. He's appeared before all BC courts and in the Supreme Court of Canada. He applies a practical, informed, strategic approach to dispute resolution and leadership of insurance group. Again, it's a pleasure to have both of you here. Thank you so much for the generosity of your time and for providing some insight and some advice to our network of dental professionals who are attending. So Lara, why don't I ask you to start, maybe just talk a little bit about the bio that I just read, what your work at the College of Physicians and Surgeons entailed, and some of the advocacy you do for healthcare professionals, so we get an idea of where you're drawing on for the advice you'll be giving later.
Thanks, Julian. Thanks for the introduction. So I do predominantly work, almost 100% of my work is in the area of professional regulation, mostly defending professionals before their regulatory bodies or other administrative bodies, but sometimes on the policy and the sort of general advice, general counsel type of work. My experience working first with Harper Gray defending health professionals and then in-house with the College of Physicians and Surgeons led me to a bit of a realization that the regulatory colleges and the health professional are not always adversaries, and they are trying to sometimes get to the same result, which is, you know, the regulatory agency, the professional colleges are protecting the public, but working in the public's best interest, but sometimes that aligns with the professional as well in terms of making sure that they are meeting the appropriate standards, making sure that if there are areas of remediation or deficiencies that need to be addressed, that they are addressed, but also, you know, providing a robust defense to the spurious and the unfounded allegations and the complaints. So in that role, if there is a possibility, my tendency is to try to explore the areas of commonality between the professional and the regulator rather than the areas of dispute.
That's great, and I think that's very practical advice, and we'll see how that applies to some of the specific examples that we're going to talk about later that dentists are facing today, and hygienists and other associated healthcare professionals who are navigating a very strange and difficult clinical environment. Nigel, if I could ask you to talk a little bit about some of the work you've done. I know you have worked with the CMPA. You've represented dentists in civil actions. Why don't you talk a little bit about the civil world when it comes to liability and professional health professionals?
Sure. and thank you also for having me here and having Harper Gray here. As you know, we do a lot of this healthcare work. We represent the CMPA, and we're in British Columbia, we're the only firm that does that work. So we represent all of the health professions, all of the physicians. And because of that, we do a lot of other professional groups as well, whether it's in construction or whether it's in healthcare, like psychologists, podiatrists, optometrists, dentists, the whole range really. My side of the world is, Lara talked about cooperation and commonality. Normally by the time it hits my desk, that's broken down and we're into the world of civil litigation or hearings before regulatory colleges. And so that's when I tend to get involved. These are normally, there's lots of time for resolution in those cases, but it requires a bit more conflict and digging to get to the evidence, get people's versions of events, beef up the defense. And so normally I'm very often talking about duties of care, standards of care, causation, consent, informed consent, and all of the ripples of those and what a judge is going to accept or not accept on those fronts. In the discipline hearing stage, it's more into whether it's unprofessional conduct or not, or infamous conduct, depending on what the matter is. So that tends to be my world, and it's across the whole range of professions generally, not just dentists. And it's a very interesting world because every case is different, and it's you know, hard sometimes to pick out the individual. A lot of people like to say, you know, how do I make sure I don't get sued? And
yeah, well, that's going to be, well, that was going to be my first question. How do dentists make sure they don't get sued?
Well, they're going to have to stop practicing if that's.
So, but I would like to, you know, just as a sort of introduction, I guess, to the topics, and thanks, Julian, for suggesting such thoughtful topics. But, you know, it is a strange and very, you know, I've said the word unprecedented time. I've said the word unprecedented so many times it doesn't even mean anything anymore. But I think that dental professionals, dentists and dental professionals are probably better positioned than most people in the general public in terms of having your highly specialized training in infection control and infection prevention. So you guys have all of the tools, you have all of the expertise and knowledge available to you. And when you're practicing, just, you know, follow your basic principles, right? The well-being of the patient comes first. Accept or recognize you have limitations. And in doing so, just make sure you're fully aware of your professional college or your regulators' up-to-date policies or specific procedures or guidelines about COVID-19. Make sure you're up to date on what your public health department is saying or what the authorities are saying about prevention and infection control. And if the college is silent on any specific procedure, go to the general policy standards and guidelines of the college. Nothing really has changed in terms of the requirements for informed consent, the requirements for infection control procedures, the requirements for record keeping. And, you know, when in doubt, document, document, document. And if you have more questions that you can't answer, go seek advice.
So a bunch of points in there. I'm going to try to pull out a little bit more because I think a lot of our conversation needs to revolve around what is the role of professional judgment in these circumstances where, you know, the college has issued a new standard, but that doesn't cover everything, right? It's incomplete. And so, you know, how do professionals use their professional judgment, and then how do they document that? And you know, what role does communication, informed consent, patient informed choice have to play in risk management. So before we move on to the COVID-19 landscape and how that's impacted the practice of dentistry over the last, let's call it 6 weeks, I want to explore a little bit more with you as background, the difference between trying to defend a dentist against an allegation of professional misconduct before their regulatory body, and how you would defend a dentist against an allegation of civil wrong in a professional malpractice case. I think these are both areas of risk for healthcare providers that we would like to avoid and to minimize, and to the extent we can avoid them, to set ourselves up for success. So if we could understand a little bit, how would a civil allegation arise, and what would be the mechanism of defense for a dentist? Maybe Nigel, you can start, and then Lara, maybe you could talk about how would an allegation of professional misconduct, where would that come from, and how would a dentist go about trying to disprove that, and what are the differences and what are the similarities?
Mm-hmm.
Sure. Well, starting on the civil side, every medical civil suit has at its heart the concept of negligence. And there's several elements to that tort. The first one is there a duty of care owed. And that can come up from time to time. For instance, if a dentist is visiting with a patient, the patient's husband came with her while the husband was standing outside of the dental practice and tripped over the sidewalk.
Or caught COVID-19.
Yeah, the dentist would not owe that husband a duty of care. Now, obviously, with a patient, you owe them a duty of care. And so the second question then is, well, what is that care standard? And that's the standard of care question. And that's completely situational. And generally, the courts have approached it on the basis, are you doing things in line with your professional peers? And you're allowed to make mistakes, and you're allowed to have an adverse outcome. But as long as you're doing the right things and what the group as a whole is doing, bit of a herd mentality in that sense. It's like, well, so whenever we get a civil case in, the standard of care is the issue, we go out and we go to another dentist, and we would say, or another hygienist, or another officer who works in an office, and say, well, this is what the presenting facts were. This was the history. This is what the treatment plan was. Does that fit what you would say would fit the standard of care of a professional peer? And a lot of people say, yeah, I may have done it differently myself, but that's an entirely reasonable treatment plan and an entirely reasonable reaction to that situation. And that's what feeds into this, like, what are we doing in the last 6 weeks scenario? Traditional standards of care are built up over decades of education and work, and we've developed a system for doing things. And, every now and then there's a new technology and a little push on the edges. But now when you're talking about what's the standard of care for telemedicine or seeing somebody in this era, that is developing. And it would really, I would defend that type of lawsuit by doing the exact same thing, going to another professional dentist or hygienist and saying, is this reasonable in light of COVID and the protocols that we had in place at the time? And that would defend standard of care. Now, within standard of care is the concept of informed consent. And informed consent is part of negligence and standard of care. And it's just, did you obtain consent in the same way that other professionals in your group would have in that situation? Again, traditionally, we've got a very traditional approach to it. And now in light of COVID and telemedicine, we have a very different approach that incorporates the old one, everything you had to do normally, and adds in a couple of new features. And for instance, for a lot of my clients who are doing telemedicine now, I remind them, you also have to get their consent to do telemedicine.
Yeah.
It's one thing for them to turn it on, but then you've got to say, you know, we're on the internet. The internet is not secure necessarily, as confidential as my office. I'm assured the service is safe and secure, but I don't really know. I'm not a programmer, just so you know. And then you've got another secondary issue. What happens if it goes down in the middle of the appointment? Do you have a backup plan in place? So there's sort of different levels of consent now with telemedicine. You just have to be sensitive and use your common sense to explain to them that it's obvious you're doing telemedicine, but we're going to talk about it some more. And then the final issue on any civil suit and defending one is causation. And you know, interestingly, you touched upon it with my husband analogy on the sidewalk. He got COVID, but it wasn't from us.
Right.
So if anybody ever sues somebody, they have to prove not only that there was a breach of the standard of care, but that breach caused the injury. And this can be a very, very complicated issue and very interesting at times for the lawyers and certainly for the science of it. And I had an old eye case years ago where somebody was hammering on a transmission and a piece of metal flew up into somebody's eye, goes into the ER doctor, and the ER doctor didn't take an x-ray. Person went blind the next day because there was a piece of metal in his eye. Turned out that he could only be on the operating table within 12 hours and he was going to be blind in 2. So no matter, even though there was a mistake, the injury was going to happen in any event. So those are sort of the layers of defense, and causation would be in the COVID era. Well, how do you know you got COVID from my office and not someone else's?
Right. So first you'd have to have the negligence before you, well, you could defend on causation. Like, I didn't cause your harm, so therefore I'm not liable. But you could also defend on the standard of care, whereas even if I caused your harm, I did everything that a reasonable dentist would have done, therefore I wasn't negligent, and therefore I'm not liable. I'd like to know, Lara, is causation relevant when it comes to an allegation of professional misconduct? So let's say, using Nigel's example, that failing to take an x-ray was an extreme departure from what a reasonable ophthalmologist would have done in that case. Can you go to your college and say, yeah, well, you know, the patient is blind now, or to use a dental example, the patient has lost, you know, their anterior teeth, but I didn't cause it, even though I was negligent. Is that going to be a successful avenue for defense against the regulator?
You could try, but it won't work. It's a good try though. I like that. No, first of all, you know, the college, the reason causation is important in a civil case is because causation determines damages, right? So monetary damages to make the person whole because of the loss that was suffered due to the breach of the standard of care. And the colleges, as you know, they don't award damages. Their role is to protect the public by establishing and enforcing the standards for the practice of the profession. So in Nigel's case, or in the way you described it, if it was a significant departure from the standard of care of any ER doctor, then the college is going to be, or any dentist, then the college is going to be concerned, is this an isolated case, or does this speak to you know, an overall pattern of practice that indicates that that person may not have adequate skill and knowledge to practice a profession? Or is it such a egregious breach of the standard to constitute intentional or reckless neglect or disregard to rise to the standard where it may constitute professional misconduct or unprofessional conduct? So it has sort of, the college sort of has two sticks in those situations. One is a review of the skill and knowledge of the practicing dentist, and the other one is to proceed with discipline if it is seen as a significant and unexplainable breach of the standard to rise to the level of disregard, intentional disregard, or neglect.
Great, perfect. So I think what I'm hearing is a similarity between the two is that if your patient doesn't like you, you're more likely to have both kinds of liability. And B, it comes down, the negligence part is relevant to both.
Mm-hmm.
So in a college complaint, if you didn't meet the standard of care or you failed to implement reasonable practices, you can end up having, perhaps a case that goes to discipline or a case that ends up with some sort of sanction at the college. And in the same way, that would be relevant in a civil case. Nigel, I think you were saying in a civil case to establish that someone was negligent, you rely on expert evidence. Lara, is that something as well that the college does, or how do they establish, that somebody in fact did conduct professional misconduct?
So that's a really good question, because that's the tenet, I guess, of a self-regulating profession like dentistry, like all the health professions, is that self-governing professions mean that the experts, other dentists, are evaluating and reviewing the standard of care. So in some way, the college can argue that its inquiry committee, its preliminary review committee that looks at the complaint or looks at the issue, has the necessary expertise to determine what would be the appropriate standard of care. And it's up to us as defense counsel to say, no, wait, your board, or you're not your board, but your committee may have some general dentists or may have some family dentists, but this is an orthodontic case. This is a case involving some sort of specialized expertise, or present an alternative expert opinion if we think that would be helpful in the defense of that complaint or that issue before the college.
Great. So in that sense, expert evidence is important for the defense, certainly, of both kinds of liability. Let's now move into the current state of affairs. So you're both aware that across the country, coast to coast to coast, the regulatory authorities in each of the provinces have essentially ordered their members, their registrants, to provide only emergency care. So I'm going to ask some specific questions, and you guys can maybe address them based on past experience or current cases that you have in front of you. So one of the questions that I've been getting from a lot of health professionals is, am I abandoning my patients, right? So colleges have said only emergency care, only orofacial trauma, broken bones, teeth that have avulsed or been knocked out, uncontrolled bleeding, prolonged pain, or severe infection. Those are the only kinds of conditions that can be treated by a dentist today. Now, I've heard from a number of our partners and associates that they have patients who a bridge has broken or their crowns have fallen out. And often this is either in the gray area or it's clearly not emergency care. However, their patients are living in a state of embarrassment, of inconvenience, of discomfort. Have they abandoned their patients? Would they be liable for a complaint? And after you've answered that question, what can they do to try to mitigate the risk in these areas? Why don't you, Nigel, start maybe from civil case and just from practical experience?
Yeah, certainly from a civil case, I don't view it as an abandonment at all. If that is the treatment standards that are prevailing at the time, then it's entirely reasonable for you not to treat, the example like a crown or a bridge or something that's broken. Because that's what the profession as a whole, through its regulator, has suggested is appropriate and reasonable in the circumstances. Now, the difficulty I find arises is the, patient's view of urgency and emergency, very different than a college's or the professional's sense of it. Everything's urgent if it involves me. So you could get a lawsuit for something like that. I would like to think there'd be good defenses, and that's the problem with the civil system. There is no gatekeeping function at the courthouse. The clerks will stamp anything that's put in front of them, and then it's a lawsuit. But it's the quality of the defense, and I think there would be a very strong defense to any lawsuit like that that says, you know, I wanted my bridge fixed and you refused to see me, and because of that I was embarrassed for a few weeks or a few months. So I don't see it as a significant liability risk. The difficulty.
So when you talk about,
sorry, just finish the thought. The difficulty, of course, is teasing out whether it's urgent, because at the same time, some patients may view things as urgent or not urgent. Sometimes they may view it as non-urgent and not give you the enough history for you to make a determination. It is urgent and you do need to come in to me. And I'm concerned about that area sometimes, and how you tease that history out properly such that they don't suddenly have a terrible event and you were in a position to do something about it but didn't.
that's a great point. That is actually, and I'm glad you brought that up, because I think for most dentists, they're struggling with being unable to provide the level of care that they're used to providing. But there's also very much, you know, the situation where a patient calls and says, I'm in a little bit of pain, and I have a little bit of swelling.
Yeah.
And, you know, in order to prevent a negative liability event or God forbid harm, but you know, what would you recommend a health provider do in these kinds of situations when they're providing care over the phone? This is not what they're necessarily, you know, we're trained in dental school to do. How do we mitigate these risks that you've brought up?
Well, Lara mentioned it at the beginning, and I'll let her take off with this. It's the documentation, because it will, in a subsequent lawsuit, they will say, oh, I didn't say it was a minor problem. I told them it was terrible. I told them I had intense pain, major swelling, and the dentist will be left, oh, it was a phone call, I didn't make a note. And then you'll be in the situation, if they have a clear memory and you have no notes, it's problematic. So documenting all of your interactions with patients during this time. So, and writing down histories as they're given to you. If you ask some probing questions, maybe note the question you asked. Right? They say they've got swelling, and so you say, is there discoloration? Is there any substance coming out? Is there anything else? So that you can show that you've done a little thought process and worked your way through it with them. And again, document that as well. Lara?
Yeah, just to add to that, in terms of how to, you know, if a patient is saying, look, I have a bridge, it's very uncomfortable, I can't, it's embarrassing, and I think it's an emergency. Look, I think the practical solution in some of these cases is to make the college the fall guy or the bad guy, because the college has, across the different provinces, set out very, very clear guidance for what constitutes an emergency, what constitutes essential services, and what is non-essential or elective services for dentists. So look, you could say to them, look, I appreciate that this is urgent or an emergency for you. I would normally be able to fit you in, and I understand your concern, but I simply cannot, because my college has made these recommendations, and it's on the college's website. If the guidelines change and if the restrictions are eased off in the next few weeks, I'll keep you posted and then follow up, right? So it is similar to a lot of college policies. There are a lot of dentists who may, and other health professionals who may want to do things that are outside of this policies or standards set out by their professional. And I always say to them, look, if you have a patient who's insistent or being a little demanding, refer them to the policy when you say, look, I can't prescribe opioid medications for you in these circumstances, or I can't renew your prescriptions. This is obviously the non-COVID area, but I can't renew your prescription for narcotics without an in-person assessment. If you have patients who sort of push back, go back to the college policy or standards and say, it's because I'm not permitted to by my college.
Yeah, and so I just want to say, having worked at one of the regulatory colleges, and Lara, I know you worked there as well, and if there are any of our dentists or lawyers or officers from the regulatory colleges watching, we appreciate all of the work you're doing, and to the extent that we make you the bad guy, we also appreciate that you're looking out for the public interest, and you make our lives a lot easier by making these rules clear and we can follow them. But it certainly helps us when we're having these difficult conversations with patients. I want to dwell a little bit on the topic of good records. So from your experience, Lara, at the the College of Physician Surgeons of British Columbia, like, how important is it to have clear, comprehensive records when you are trying to defend yourself against allegations?
It is key. Most complainants and most litigants do not bring on their lawsuit in anywhere near like the day that they're seen or the week after they're seen. Sometimes takes months, sometimes takes years. In the COVID area, the limitation periods have now been suspended, so it may take longer than normal. So you're not going to remember what happened in that encounter, given the fact that it's part of your standard practice, whereas the patient or the complainant or the claimant is going to have in their mind a crystal clear recollection of everything you said or did not say to them in the context of that consultation on the phone or in person. So you write it down, you develop standard policies, or you standardized interview questions. So one of the things you may want to think about, if you haven't done tele-dentistry before, is what are the things I would normally ask in the office, and what are the questions I would ask in place of an in-person assessment or examination? What are the things I really want to know, right? And so if you have a standardized interview question list and you go through that list and you write down your answers, that forms a good and permanent record of the encounter, and you can rely both on the record itself, and you could also rely on the answer that you had and you followed your standard routine process for doing something.
Thank you, that's helpful. So I'm just going to say this from a practical perspective, and I know Nigel, to your point of causation, there are always defenses that you can make. You could take the record and throw it out the window and still have a plausible causation defense in civil litigation. I think in a regulatory proceeding, if you threw your patient chart out the window, that would just add another headache to the one you already had. But just from a practical perspective, whether it's a judge or a jury or a committee of your peers at the regulatory body, when they see carefully taken, legible, comprehensive chart notes, take away the merits of whether or not this dentist did what she should have done. Does that have an impact on the way those cases go?
Yeah, no, it's tremendously important, and it's the nature of civil litigation. I always tell people I'm in the competitive education and image management business.
Right.
One camp is trying to prove the earth is round, another is trying to prove the earth is flat. We have a competitive education system. And so I am educating the court on my view of the world, but also on the image of this healthcare professional. So I had a client once, a podiatrist, who had an informed consent case. And he was the most diligent, person I'd ever seen in my life, and was asked under cross-examination to explain his informed consent procedure. And it was ridiculous. He had this ability to write upside down. And I guess when he goes through his form, he would circle things and write things as he was doing it. So his informed consent form from this particular patient had lines, circles, words written beside it, diagrams on it. And his answer he gave was 30 minutes long. Like, everybody was exhausted after he finished. And the whole thing was like, everybody was like, oh my God, this guy is not the kind of guy to skip details. And a chart note is the same reflection of that. If you have a chart note that's nothing more than a billing guide, then a court is going to look at that and say, well, this does not seem like someone who is taking the time to be diligent and thorough in their approach to medicine or dentistry or any other health profession that they're engaging in. And it's very hard for me to come back from that, because people will cross on those issues and say, you know, sir, you say you've got a perfect recollection of what you did on this session, but you're emotions vector. But you would agree this chart doesn't indicate anything you've done. That's right. So you're completely relying on your own memory, right? And you've done how many of these procedures since you saw my client? Oh, I've done about 10,000 of them. So to suggest that you remember my client's procedure is ludicrous, isn't it? And
Yeah.
there's, oh, I remember that one. And you'll be like, but you said you just did 10,000 of them. Tell me about the one after you did my client.
Yeah.
Right? And it just all falls apart. So if you can point to a note, and if you can point to, I asked them this question, they gave me this answer, I did this history, I did these the old SOAP format, then you're off to the races. Now, I get in a busy practice and on some minor things that you may use some shorthand, which is okay. As long as there's some evidence of it. You just got to manage that. And I think if we're doing unique things like practicing in this current climate, you may have to go the extra mile until things settle down a bit.
Great. That's very helpful. Is it similar in the regulatory world, Lara, when it comes to records?
I think so. I mean, I think it is. There are all colleges have record-keeping standards or policies, and you have to follow them in terms of what needs to be in the record. Nigel talked about the SOAP format. But key, I think, in this COVID era is because you're not having that in-person assessment and you're doing a lot of triage work where you determine whether or not someone is falls within the category of emergency. It's very, very important that that be clearly documented and somehow makes its way back into the patient record, understanding that a lot of dentists are probably not. They may be working from home or they may not be in their physical practice.
That's great, thanks. So we've talked quite a bit about dentists providing remote care, which is what the vast majority are doing right now. For those who are on the front lines, who are scrubbing up and putting on their N95 respirators, and treating patients in the clinic for their emergent concerns, whether it's infection or pain. I'd like to talk a little bit about strategies similar, maybe dissimilar, that they can implement to ensure smooth interactions and positive interactions with their patients and to prevent any headache down the road. So one of the situations that's coming up or that has people somewhat concerned is that in many instances, regulatory bodies are telling their members, their doctors, to provide the minimum care necessary to deal with the emergency. And for many dentists, that is extremely unusual. It goes contrary to every fabric of their being, which wants them to provide comprehensive, best-in-class, thorough, whole mouth care. So what can dentists do when they're in a situation where they could take heroic measures to save somebody's teeth, but given the college's restrictions and parameters, they're extracting teeth that possibly, could have been saved. How could dentists in these circumstances protect themselves from liability down in the future, and also maybe convey the unusual circumstances to patients in an effective way?
I think you hit the two nails on the head. It's communication. Informed consent is all about communication, right?
Mm-hmm.
Ensuring that you explain all of the risks and the benefits of the procedure, but also ensuring that the patient understands them and can echo them back to you. So it's not it's a two-way conversation. And I think that in these very sort of uncertain times, there's probably a bigger role than even before in terms of making sure the patient fully understands the procedure that you are recommending, the fact that it may not be optional care, but it is emergency care for the time being, and what you are planning or what the patient should do in follow-up once a situation either resolves or becomes a little different, or landscape changes a little bit. And if that means having the patient in for, and I understand that these situations are never ideal. You may not, if you're dealing with an emergent situation, you may be dealing with a patient who is maybe in pain and not as capable of communicating as well as he or she otherwise could. You may be dealing with someone who may not have English as a first language, maybe dealing with a family member, but make sure you do take that time and you give them an opportunity to say, look, if you need time to think about this, this is the situation. I need to either go in and do this now, but if it's not, if you can give them a little bit of time to think about it and then come back and then explain to you again what it is they heard from you. I think that would be ideal. I know that the circumstances may not permit that, but try to tease out from the patient what they understand about what you said. And as I said, if you're going to be doing invasive or, I guess, permanent types of procedures such as extractions, have them sign a form, a consent form. And obviously signing a consent form or a written consent form is not a substitution for the discussion, but at least you have outlined the risks and the benefits of the treatment and said, well, and then the patient signs that underneath it. And that is another sort of document that can be relied upon later on if there is a college complaint, if there is a lawsuit filed.
And can I just add one thing as well? I think it's important to tell the patient why you're recommending a particular path of treatment as part of the informed consent discussion. Because if it's in the normal world, I could save this tooth. In this current world, I've been told I should take it out. I think the patient needs to understand, instead of you just skipping to the process, oh, you've got this issue, I'm going to take your tooth out. They may ask questions months later saying, well, I talked to another person and they said you could have saved it in that circumstance. Why didn't you? So I think it's necessary, not only when you're presenting the options to the patient, why you're recommending one path over the other to that patient.
And then, of course, taking records about all of these conversations to make sure if you're ever questioned that you can, that those conversations actually happen. So sticking with informed consent for a second, what about the risk that the patient could potentially contract COVID-19 during the dental visit? Is this something that should be documented? Is this something that you would have the patient sign a form? In these incredible circumstances, how does the risk of the spread of COVID play into the usual informed consent conversations?
You want me to start?
Yeah, I think in BC, particularly in BC, it's probably, and maybe elsewhere, it's more it's in the forefront of everybody's mind, because everybody, the public knows that a lot of dentists went to this convention, right, where there was a spread. I do think that if you're having the discussion and you're providing, if you're providing, these are going to only be emergency cases. And emergency cases, by the very nature of them, probably carry higher risk than, for example, a routine procedure for a dental cleaning or a cavity filling. So I think that it is, I don't know whether I would say incumbent, but I think I would strongly recommend that the risk of infection be discussed with the patient, including the potential of being infected with COVID-19.
Yeah, Lara's exactly right on that. I wouldn't add anything to that other than, having a frank talk that it's within the whole infection control regime and it's necessary to risk it.
Yeah, so, right. So I guess this is the crux of the matter. To your point before, a patient who has a poor outcome is always going to, their memory of what they told their dentist is always going to be skewed towards the, I made it clear that it was, extremely painful, when they might have said it's a 6 out of 10 or something like that. And when it comes to COVID-19, that patient leaves and goes home and goes to the supermarket and, has some conversations with their neighbors and then takes maybe the streetcar or the subway and then gets home. And then, 5 days later, they start showing signs of COVID-19, to the extent that they may sue the dentist or complain to the dentist, to the regulatory body, what is the impact of informed consent in that area? And, is it important, do you think, to document that? I just want to, because that's a risk I think that a lot of people are concerned about right now.
Yeah, no, it absolutely is important to document it. I think if you and a patient decide it's emergent enough for them to come in, I think it's helpful for you to say in the initial discussion on the phone, when you ask them to come in, that you make a note saying, ask them to come in, ask them if they were ill, because of course you have responsibility to your coworkers. Asked if they were showing any symptoms of illness, whether they had any exposure to COVID or anyone else that might have, discussed the risks of, leaving their home and coming to our practice, discussed the fact that we can't maintain minimum social distancing while doing this procedure. Patients seemed to understand the discussion I had and wanted to come in any event, period, chart. That would be an entry that I would be pleased to see in a chart. Didn't have to have all those words. It would be discuss COVID and risks of COVID. Could be the shorthand in the chart. Patient wants to come in. That's enough to sort of show that there was a discussion, and it can be a leaping off point if you're giving evidence a year later to say, oh, I had the discussion with them. Here's the entry.
And it probably doesn't need to be said, but if you as a dental professional believe that you are at higher risk of having had previous exposure or higher risk of potentially having COVID-19, then obviously I would say don't do it, but it's incumbent upon you to explain that to your patient prior to doing the procedure or seeing them in person. Now, I think that the college would find it, if a patient were to, in the scenario you described, Julian, go home, go to the grocery store, interact with family, and then develop COVID-19 and then bring a complaint to the college would be very understanding in those circumstances that, that in all likelihood, the exposure probably did not happen in the dental office, and the dental office took reasonable and appropriate prevention, PPE and disease prevention control measures to ensure that there was no transmission. However, if you as a dental professional know that you were at higher risk and did the procedure anyways, that is a basis likely for some allegation of unprofessional conduct or professional misconduct.
Right. So, I mean, I guess what you're saying is if you wake up with a fever, don't go to work.
Yes.
Really, I mean, that's probably the case always, but, you know, or if you're shortness of breath or if you have digestive symptoms, like stay home because, you know, even if the patient gets it, you know, on the subway on the way back home, you know, the fact that you put them at risk could land you in trouble with your regulator, regardless of whether there's a causation defense there. Now, we're talking about record keeping. Do you think it's important for healthcare professionals to document the heightened infection prevention and control measures they're taking, or the heightened level of personal protective equipment that they are wearing during these procedures? You know, if there was ever a complaint or a lawsuit, how would that evidence be best marshaled, you know, to defend a healthcare professional? And what would you like to see? Is it standard operating procedures, specific chart note entries?
Yeah, I would find it in a civil case. It's a bit unusual to have it as a chart entry. You know, this is like your normal infection protocol in your office.
Mm-hmm.
You know, that would rarely be seen in a chart entry, but it would be very nice to see it in a standard operating procedure that's somewhere in the office,
Mm-hmm.
that someone could produce. I think that would be very helpful. You know, I don't necessarily see it in the chart. If you wanted to be really diligent, you could certainly say something in a chart entry that would just be, you know, enhanced COVID precautions initiated.
Yeah.
Lara?
So in BC, there's a standard that says that all dental offices have to have an exposure management protocol in place, right? So you already have that. And if you're doing procedures in this COVID area, just say exposure procedure policy reviewed on this date and enhanced with these measures. And that as a living document outside the patient chart would be something I would like to see if I was defending a dentist or a dental office.
So some way of showing essentially that you've been adhering to best practices or you know, the new requirements for PPE, whether that's a dated policy or a mention, you know, in the chart note, maybe a template entry that suggests that the appropriate personal protective equipment was used. I want to jump into privacy for a second, because it's been coming up in a couple of interesting ways. And to the extent that, you know, you could comment on, should we be concerned and how do we mitigate those concerns? I want to run a couple of scenarios by you. The first is practicing tele-dentistry. You know, you're creating a lot of people chart notes or entries outside of the practice management software. So, you know, you may be, you know, potentially using a tele-dentistry platform that you're not accustomed to using. You might be using email, telephone, Zoom. There's a whole bunch of places where personal health information can end up. And how do we make sure that we don't end up on the wrong side of a privacy complaint? That's the first. The second issue is, let's say a dentist or a dental assistant tests positive for COVID-19. You know, what is that staff member's right to privacy versus what are the obligations of disclosure to other staff members and or patients that they've been in contact with?
Maybe, Nigel, I'll tackle the first question maybe, and you could tackle the second.
Sure.
All right, so look, I think the privacy policies, the privacy policy is established by the college and also by the Office of the Information and Privacy Commissioner, is the same regardless of COVID, regardless of pandemic. It's the same, right? So I don't think that you get an exemption simply because we're in a different area for maintaining and protecting sensitive personal health information of your patients. Now, telemedicine and these platforms and these EMR providers, they're all great, really good technology. It's a way for a lot of health practitioners to practice in this time. But they're, you know, in Zoom, I guess they're the, it's a new thing. It's maybe not the new thing, it's just a new thing for me. But, you know, if you're dealing with some really sensitive personal information, you know, sometimes the safer way to deal with it is in a phone call. You know, there's something to be said for face-to-face, being able to see the person, to sort of look at, you know, whether they have swelling, to see whether or not they have, you may be able to see in their mouth if they have their camera positioned correctly. But if it is something very, very sensitive, just get off the Zoom call or get off the internet and have a telephone conversation with them. And when it's possible, try to upload that information, record it in your permanent patient chart, if that patient is a patient in your practice. There are certain requirements in the Canadian privacy laws about where you host or where the server is, whether it's remains in Canada or outside Canada. You may wish to speak, if you're using a platform you're unfamiliar with, if you're using a platform where you don't really understand how to record records, you may want to get some advice or tutorials on how to best manage privacy and best maintain medical records before you start seeing patients.
Great, thank you.
And just on the privacy thing, you know, I just always start on the basis that you need to just explain, like I said, we're on the internet, it's not necessarily confidential. Although I was giving a talk to another health professional group and they said, well, Zoom's great, can I just record all of the sessions and that's my notes? And I said, well, do you walk into a clinic room and turn on a tape recorder when your patient's there? Probably shouldn't be recording Zoom sessions as well. Certainly you would need their consent. Certainly you would need to figure out where it's getting stored because it's not your office. It's
Correct.
a server that may be in Bermuda or the Ukraine or who knows where it's going. So you gotta be very careful about that. To get to your employee question though, look, if you had somebody in your office who was diagnosed with COVID or with a presumptive case of COVID, they have a right to their own healthcare privacy, but I think you could say, look, we've had a COVID exposure in the office. I'm not saying who, but we've had a COVID exposure in our office. And so here's what we've got to do. It out. So I would just not name people. So if it was in our office, we have a lot of employees. We've got about 200 employees at our office. We would simply say, there's been a COVID diagnosis in the office or a presumptive case of COVID. Because of that, we've got to shut the office, do a full disinfect. You all have to stay home. If you're on this floor of the office building, you've got to stay home for 14 days or something like that. But we wouldn't disclose the employee. So I think that's where the line and limit is going to be. And, you know, if you did have questions about that, again, this would be a great area to call the college. Say, hey, I've had a diagnosis in my office. What am I allowed to tell and not tell? Or to call a lawyer or call yourself, Julian, or somebody to get some advice on this.
Yeah, or the public health authority in your province or your region also could probably provide you with some helpful information. So that's helpful. What about when it comes to, you know, if a patient tells you, as opposed to a staff member, hey, you know, they called 2 days later, oh, by the way, I tested positive the day after I received that dental treatment. You know, is the same principles of privacy apply? Or at that point, I mean, you know, to the dental assistant who was chairside for that treatment, you know, like what is the thought process between disclosing that patient's health information to maybe people who are already in the circle of care versus other patients who might have been in the office and may have been exposed to that patient? So.
Well, yeah, there's certainly different levels. I would always be reluctant to be specific about somebody. I would say, look, we had a patient in the office who's called me and said they've been diagnosed with COVID. Everybody needs to know that in the office. Here's what we're doing. Here's what we're recommending. And then, of course, you may have further obligations to your other patients.
Mm-hmm.
The patient that came after that person and before that person and everybody else who went through that chair that day.
Mm-hmm.
And again, you'd have to take advice from the public health people or the college about what steps to take in that scenario.
Yeah, I would add to what Nigel said and say, you know, it's the same with the employee situation. You don't need to say that it was a patient or an employee at the office that had an exposure. You could just say, look, our office has had a COVID exposure, be non-specific about where that exposure came from and say, look, and we're notifying you as a result. I do think that you do have an obligation to let people within, you know, who may have had some exposure know, but you have no obligation, and there's no, as far as I know in BC, there's no mandatory reporting of the individual.
Thank you. We've been going for an hour, so I'm going to ask a few more questions and we'll wrap it up. If there's anything that I should have asked that I didn't, I'll ask you both to let me know. I've had a couple dentists ask, you know, Tele-Dentistry is so different than what I usually do. Will my malpractice insurance company, CDS, PI, Viva, or PLP, will they be covering me if there is a lawsuit? I've looked at the policies, and essentially it says that, you know, the coverage extends to the practice of the profession. What would your advice to them be, to a dentist who's worried about potential exposure or lack of insurance coverage, Nigel?
Yeah, you know, most errors and omissions policies have a definition of professional services within it.
Mm-hmm.
As long as you're practicing within the scope of professional services, you would get coverage. Those professional services definitions are very broad and tend to be anything that is related to your profession.
Mm-hmm.
And they're kind of circular that way. So certainly if very suddenly the new norm becomes having to do things over the telephone, if your college is suggesting that this is what has to be done, then you're going to fit within those professional services definitions pretty obviously. And I would be very, very surprised if an errors and omissions policy wouldn't respond to care that you were providing, whether it be through video or telephone or in person.
Mm-hmm. So that's reassuring. So in other words, from what you've seen, these kinds of professional malpractice policies, they tend to cover the territory. And I've seen a number of the regulatory bodies issue statements that say things like Tele-Dentistry is the practice of dentistry.
Yeah.
You think that's some sort of like a dog whistle?
It would be very powerful evidence on the coverage action.
Yeah.
When I would say, look, of course this is professional services. The college says it's professional services. If they wanted to exclude it, they ought to have used specific language to exclude it.
Yeah.
And ambiguities in policies are always interpreted in favor of the insureds. So, you know, I anticipate I would be in a very strong position on that sort of thing. And with pronouncements like that from the profession and the colleges, it would just, I think it would be a very, very difficult case for an insurer to avoid defending.
I wouldn't be politically very popular to try to
that as well.
bring a healthcare professional on the front lines either.
The only point I have to add to that is, you know, obviously make sure you do practice, if it's tele-dentistry or any other practice of dentistry, make sure you practice in your lane, right? Stay within your scope. I understand that, you know, lots of patients right now, they're looking for health advice from every and all health professionals. So there's a lot of demand and there's a lot of pressure placed on every health professional for advice about things. And so if you're dealing with someone who's asking you about opioids or antibiotics for dental pain or a dental problem, and they start venturing into the area saying, you know, will these antibiotics also help? I can't get in to see my doctor. Will they also help with this? Or, you know, I need more opioids because I can't get a prescription renewal from my family physician for something, and you know, I need you to help me out. I just think that, you know, make sure all of that applies. The colleges are going to be very, I think, with their policies about teledentistry, they're going to be sort of very, very sort of understanding if you're doing teledentistry, to make sure it remains in dentistry.
That's a great point. So, and we've had some cases recently, people have contacted me where individuals were exhibiting drug-seeking behavior. So, Lara, what would you say in this circumstance where a patient calls in and says, you know, I need, you know, my tooth hurts, and you know, I can't sleep. I've been taking Tylenol. Tylenol is not working, and you know, you say, well, you go through the whole process and decide, you know, maybe this is a case that's reasonable to prescribe, you know, Percocets or another opioid family drug. And then, you know, at the end of the conversation, you know, the patient says, oh, that's such a relief. My back has really been bothering me. If you're a dentist, you know, what are the next steps you take if you hear something like that from a patient?
I think the same advice applies whether it's teledentistry, whether it's COVID or not COVID, is, you know, do the necessary assessment and involve those within the circle of care in your treatment decisions when it comes to prescribing anything, any systemic medications or treatments, right? So the GP should be involved in that discussion, and the prescription, a copy of the prescription should, or a consult note should be sent to the family physician in those circumstances. But again, this is an exercise of professional judgment, and all of you are professionals and you have come across a situation. So if it doesn't meet the smell test, you know, there are other alternatives, non-opioid alternatives for pain that you can suggest. And if they are saying that this is extreme pain, then they probably do fall in the category of emergency and require an in-person assessment. So I think that in that circumstance, if someone is asking you for, especially if they're saying, look, they're asking for their medication of choice, such as Percocets or Tylenol 3s, you could say, look, you know, I think your situation sounds serious. It could be some infection, systemic infection. It's something we need to look at. I would like you to come in or refer them to an alternate dentist provider who can see them on an emergency basis and do that in-person assessment before determining whether or not the opioid medications is indicated for that dental condition.
Mm-hmm. So I have a bit of a potpourri of questions here at the end that I'd like to address because I know that dentists have been struggling with this. Nigel, can you tell me what it means to form a dentist-patient relationship? And in the circumstance where dentists are treating people they've never seen before, who have another primary dentist who perhaps isn't open, they can't contact, they're treating somebody who doesn't have a primary dentist and they're only talking to them on the phone. You know, has a dentist-patient relationship been formed to your sort of duty of care conversation at the beginning, A, and B, can you limit the scope of that relationship so then, you know, you're not necessarily responsible for everything having to do with that person's oral health for months and years to come? What are some concerns or tips that people could take away around that?
Yeah, it's my view a doctor-patient relationship is formed anytime there is medical advice given or dental advice given to a patient. Lawyers, fortunately, have something called cocktail advice, which is what people have at cocktail parties and they get what they pay for, according to the courts. Dentists, I suspect, if somebody gets in for an official visit where you open a chart, then they're a patient. Now, whether you can limit the care that you're providing them, certainly it would be helpful if you say, I understand you're just coming to me for one particular issue on one particular occasion or a couple of occasions to deal with that issue, and your primary care dentist is so-and-so. I think then that it's helpful to have a chart note to that effect. And to talk about the circle of care issue, also probably to send a quick note to that primary dentist and say, your patient came and saw me for this issue. I told him X. and sent them back to you.
Mm-hmm.
You know, just so that everybody's in the loop on the issue. But yeah, I hope that answered the question.
No, I think that does help. So, you know, I don't know if there is a scientific, you know, answer to whether you could successfully limit the doctor-patient relationship, but you can take steps to demonstrate that your responsibilities was strictly to the chief complaint or the primary complaint, and that you very much intend that patient to return either to, you know, another primary dentist, you know, or perhaps one you don't know, to limit, you know, the ongoing responsibilities you're going to have.
Exactly.
It's a tough decision. You know, there are dentists whose practices are, for all, you know, intents and purposes, full, where, you know, they wouldn't be accepting new patients, but with the COVID-19 crisis, they're doing tele-dentistry, they're seeing emergencies, and so all of a sudden they're practicing in a way that is very alien to them. And so, you know, these are the kinds of things I think that are keeping some of our doctors up at night. Are there any topics, Lara or Nigel, you feel I should have touched on, or, you know, perhaps you're getting questions from your other healthcare clients that may be applicable?
The only hot one I said was, concerned me, was don't record Zoom sessions. If that's your care.
Yeah, so let's query that. So would a recorded Zoom session, if you and I now were having a conversation and I'm describing pain or you know, an infection that I have around my wisdom tooth, and you're a healthcare provider and you say, this is being recorded, is this part of my chart?
Well, that's where we get complicated. First off, most jurisdictions are a dual consent to record. Right. So both parties have to consent. So you would have, before you even turn on the record button, you'd have to ask your patient and explain that you're going to record it. It's going to be saved on some server in the internet. Are you okay with that? Right. And it creates a risk for you, because when they sue you for recording them without their knowledge, it's another risk you've taken on.
So step one is consent.
Oh, absolutely.
Step one is consent, and explicit consent.
Yes. And then the next stage would be, is it part of the chart? I think so. It would be a piece of information that's diagnostically relevant and is a recording, but I just, look, you don't do it in a regular office. Why on earth would you suddenly, in a high-risk environment, start introducing a new risk? And a new
don't do it. Yeah, no, I hear that's your advice, and I think it's sage advice. Yes. So Lara, let's say you're sitting on a panel, committee panel for a regulatory college, and a patient has complained, and they say, you know, well, my dentist recorded our conversation and I explained X, Y, and Z to the dentist, go get that recording. If the regulatory college went to the dentist and said, did you record this? And the dentist said, yes, I did. Would you expect the dentist to be able to provide that recording?
Well, that's a good question. It depends on, you know, it depends on the technology, right? The dentist may, I mean, right now I could see that we're recording this section, which is fine. And if someone said to me, you know, 3 years down the road, hey, can you please provide me with the Zoom session that you did on this date to prove in a divorce proceeding that you weren't doing something you shouldn't be doing, and you were actually in the office doing a video conference, then I would say, I have no idea how I was going to get that. I have no idea where I would get that evidence, right? So I think that if you're going to be using technology, again, going back to this, if you're using technology you're unfamiliar with, don't get taken in by all the bells and whistles, right? And say, look, there's this record function. I don't know where it goes in this cloud or on the internet, but I'm going to push it just so that I have that extra piece of evidence. The college can, you know, every registrant has a duty to cooperate with the college in an investigation and provide documents. Similarly, there's disclosure requirements in civil cases. So if you can get the evidence, then you will have to provide it. But you're going to be dealing with a different problem with a college if you said, yes, I did record it, but I have no idea where it's stored, or I have no idea how to recover it. And finally, a recorded session is not a substitution for a written clinical note.
Well, that's important to know. So if a college asks you for a recording and you can't provide it, you're not going to look great, in other words. So, and much less if you don't know where it is or who has access to it, that's also another concern. So, and this is something, I see a lot is a patient will have a clinical complaint that goes nowhere, but it turns out the dentist's records were absolutely horrible, and the dentist ends up getting in trouble because their records are horrible. Or, a patient has a clinical complaint that goes nowhere, but, in the course, they receive their chart, and all of a sudden they see that their chart, on personal health information, an ex-husband was copied on some personal health information, and then all of a sudden the dentist has a privacy complaint. And so, it's important to keep all of these things in mind, because if you ever do have to provide the chart, it's going to reflect on you regardless of whether or not technically, you're a fantastic clinician. So we've been going almost an hour and 20 minutes. I just want to thank you both for your time, again, your generosity and the insightful comments you've made, for your willingness to provide our audience with your advice and recommendations. And, I really, really appreciate it. It's been a pleasure for me to spend this time talking to you and preparing for the session as well. So Nigel, Lara, thank you so much. Enjoy your evenings, stay healthy, stay safe, keep health providers out of trouble, please.
I thought you were going to tell me to floss or something. Isn't that what all dentists say?
Please floss. Yeah, no, don't, you know what? Don't eat any hard nuts right now. Avoid popcorn, because you'll have trouble finding a dentist if you crack a tooth. But in all seriousness, it was fantastic. It was a pleasure and an honor. I'd just like to say goodbye to everybody who's joined us this evening. I hope you found this session informative, and we look forward to future sessions, and we hope you'll join us again. On behalf of dentalcorp and myself, Julian Perez, signing off, and have a great evening. Stay healthy, everybody.
Thank you.
Yeah.